Welcome. I am the loud little ducky. Today we are going to be going over Laura Owens suing Uber in 2019. We're going to do a case review so that we can see what she claims in this. Let's dive in. So it's got the Superior Court of California, County of San Francisco, the complaint, Laura Owens versus Zaid, I don't know how to pronounce the name. And then we've got, this is from Cotchett, Petrie, and McCarthy, so this must be Uncle Joe. And so it says a civil case, and then she's got the box checked for unlimited amount demanded exceeds $25,000, that it was an auto. That's what best describes the case. And it says this case is not complex under Rule 3.4 of the California Rules of Court. And then it talks about something else. Remedies sought, monetary. That's what she wants, monetary damages. And this case is not a class action suit. And they have it signed. And this was filed April 4th, 2019. And then it's got instructions on how to complete, who the defendant is. Plaintiff is Owens. More stuff, and then it's signed as well on the 4th by the court clerk. So that was the summons. All right. So now we have this filed April 4th, 2019 in the Superior Court of the State of California in and for the County of San Francisco, and it is suing Zaid, an individual, Uber Technologies, a Delaware corporation, Riser, a Delaware Limited Liability Corporation, Riser CA LLC, Delaware Limited Liability Corporation, Bruce Robert Brogenden, an individual, Inu Forest Products Incorporated, a California corporation, and does 1 through 20 inclusive. So she's suing all those people for an amount that exceeds $25,000. And it's complaint for damages based upon negligence, negligent entrustment, negligent hiring, supervision, or retention, and a jury trial is demanded, which is interesting to see. Jury trial demanded on this. She complains about it in another case. Oh, I didn't have the option for a jury trial. Well, you could have demanded it like just out front, bold on the cover sheet in your other cases, like you did here, but you didn't. It has the table of contents. So it says Plaintiff Laura Owens, Laura, by and here through attorneys of record, makes the following allegations and claims for her complaint against all those defendants that we listed. Collectively defendants, as they say. The following allegations are made upon information and belief, except as to allegations specifically pertaining to Laura, which are made upon knowledge. Introduction. On April 6, 2017, at approximately 10:45 a.m., Plaintiff Laura was an unwitting passenger in an Uber rideshare wherein the Uber driver was not insured to provide rideshare services in any manner, despite picking up and driving Laura as a passenger in the rear of his SUV when the course and scope of his agency as a common carrier driver for the defendants, Uber and or Riser. Rather than paying attention to the road, Zaid, the driver, was focused on his cell phone and suddenly slammed on his brakes, spun around, hit the car in front, and got hit by a truck from behind, being driven by defendant Bruce Robert Brogenden. Defendant Brogdon was driving a 2000 GMC Sierra pickup truck within the course and scope of his employment with Defendant in New Forest. Okay, so he's blaming both. She's wanting money from both people. Had also taken his eyes off the road in front of him and was driving his truck too fast for the conditions. I don't know how they decide that, but maybe. And how does she know he took his eyes off the road? She wasn't in his vehicle. As a result of the combined negligence of the defendants, plaintiff Laura suffered serious injuries and damages hereinafter alleged. Number 2, jurisdiction and venue. The court has personal jurisdiction over defendant because defendants are residents of the state of California and at all times relevant the events which combined to produce the injuries sustained by Laura occurred in the county of San Francisco. Complaint. This court is competent to adjudicate this action and the amount in controversy exceeds the jurisdictional minimum of this court. Venue is proper in San Francisco County pursuant to California Code of Civil Procedure 395 because substantially all of the events, acts, omissions, and transactions complained of herein occurred in originated from San Francisco County, State of California. Why can't they just say all of these things? You can list even that. Events, acts, omissions, and transactions that transactions complained happened and originated here. Like, why can't you just say these things happened in San Francisco County, State of California? Why you gotta make it so complicated? Parties. Plaintiffs. Plaintiff Laura Owens is a natural person who is and at all times mentioned in this complaint was a resident of San Francisco, California. Defendants. Plaintiffs are informed and believe and thereon allege the defendant Zaid was at all relevant times mentioned herein an individual who resides in Carmichael, California, County of Sacramento. At all time of the automobile collision that injured Laura, Zaid was the driver of the gray 2009 Ford Escape with a certain license plate. Defendant was the employee agent servant under the control of defendants Uber and Razor during the time giving rise to causes of actions described below. Plaintiffs are informed and believe that thereon alleges the defendant Uber was at all relevant times mentioned herein a transport network company incorporated in Delaware with offices and facilities located in the city and county of San Francisco. Plaintiffs are informed and believe and thereupon allege that defendant Razor LLC and Razor CA LLC are Delaware limited liability corporations which are woefully owned subsidiaries of Uber, Razor, and Razor, have their principal places of business in and they conduct business in San Francisco, California. Plaintiff is informed and believes thereupon alleges that Uber, Razor, and Doe's 1 through 10 operate a transportation network company, TNC, in San Francisco that provides mobile application app, online enabled platform connecting passengers with drivers who use their personal vehicles by allowing people to pay for rides through their phones. The popular ride-hailing service provides transportation to the general public by matching a rider with a driver who drives them to a destination. Uber, Razor, and Doe's 1 through 10 solicit and retain tens of thousands of non-professional drivers, including Zayed, and exercise control over the driver's vehicle specifications, vehicle inspections, insurance requirements, operational restrictions, dress code, hygiene standards, in-car behavior, and other mandates. Uber, Razor, and Doe's are directly liable for their negligent hiring, supervision, and retention of defendant Zayed under the doctrine of respondent superior. According to Uber, Razor, and Doe's are liable for their employees and actually and or apparent agents, international and negligent torts. Plaintiffs are informed and believed, and therein allege that defendant Bruce Brogdon was at all relevant times mentioned herein an individual who resides in Healdsburg, California, county of Sonoma. At the time of the automobile collision that injured Laura, Bogdan was the driver of the white 2000 GMC Sierra truck with the license plate. Plaintiffs are informed and believed and thereon allege that defendant New Forest Products was at all relevant times mentioned herein a corporation with offices and facilities located in the city of Cloverdale, California, county of Sonoma, at all times of the subject collision that injured Laura. New Forest Products was the owner, Baylor leaser or licensee of the GMC Sierra truck that Brogan was driving. Or Brogdon, whatever. These names are hard to pronounce. Furthermore, defendant Brogdon was the employee, agent, servant, and under the control of New Forest Products. New Forest Products is liable for the negligent hiring, supervision, and retention of defendant Brogdon under the doctrine of respondent superior. According to New Forest Products, is liable for the employees and actual and or apparent agents' intentional and negligent torts. Let's write a whole bunch of complicated mess to say this person works for this company and this company is, for all intents and purposes, in this particular location and are responsible for these things. Like, why do you have to write such complicated messes? I get it needs to sound professional, but does it need to be so confusing? Other defendants. The true names and capacities, whether individual, corporate, associate, or otherwise, of the defendant Doe 1 through Doe 20, inclusive or unknown to the plaintiff, who therefore sue the defendants by such fictitious names pursuant to the Code of Civil Procedure and 474. Plaintiffs further alleges that each of the said fictitious defendants is in some manner responsible for the acts and occurrences herein set forth. Plaintiffs will amend this complaint to show their true names and capacities when the same are ascertained, as well as the manner in which each fictitious defendant is responsible. So we have a bunch of Jane Does and John Does, 1 through 10 or 1 through 20, that are also a part of this wreck that caused it. That's interesting. I feel like none of the Does have anything to do with it. Agency and concert of action. At all times herein mentioned, defendant in each of them herein above were the agents, servants, employees, partners, aiders and abettors, co-conspirators, and or joint ventures of each of the defendants named herein, and were at all times operating and acting within the purpose and scope of said agent, service, employment, partnership, enterprise, conspiracy, and or joint venture, and each defendant has ratified and approved the acts of each of the remaining defendants. Each of the defendants aided and abetted, encouraged, and rendered substantial assistance to the other defendants in breaching their obligations to plaintiff, as alleged herein. In taking action to aid and abet the substantially assist to the commission of the wrongful acts and other wrongdoings complained of, as alleged herein, each of the defendants acted with the awareness of his or her or its primary wrongdoing and realized that his, her, or its conduct would substantially assist the accomplishment of the wrongful conduct, wrongful goals, and wrongdoing. So everybody that is associated with everybody in this is responsible for all this. And they knew their wrongdoings. Factual basis for the claims asserted. Laura requested a ride from Uber at approximately 10:30 a.m. on April 6, 2017. Zayed picked her up in a gray 2009 Ford Escape with a California license plate and began driving her across San Francisco. As Zayed drove Laura through the MacArthur Tunnel in San Francisco, he turned his attention to his phone and away from the road. Zayed suddenly slammed on his brakes to avoid hitting cars ahead of him. The force of the stop caused him to spin around, hit the car in front of him, hit the tunnel, and stop facing the wrong way just outside the tunnel. As Zayed spun, their car was hit by a white 2000 GMC Sierra truck with California license plate being driven by Defendant Brogdon. Defendant Zayed so negligently, wrongfully, recklessly, and or unlawfully operated his vehicle that Laura suffered injuries. Defendant Uber failed to use due care in hiring, supervision, selection, and retention of Zayed. Defendant Uber knew or should have known that Zayed was unfit or incompetent to safely operate his vehicle. I don't know how Uber knows that or is supposed to know that. Unless Uber starts putting cameras in all of it. And then somebody is hired to watch those cameras to make sure that all million drivers are behaving. I think they expect that you have a driver's license and that you know what the laws are and the rules of the road and that you're not to be on your phone. I think they just suspect that. I don't think Uber knew that he did this or how they would have known. What would be a better way for Uber to know about their drivers? I mean, let's say his driving record was clean, because if they did that kind of thing, if they hire somebody who has a bad driving record, that'd be one thing. But if they hired somebody who has a clean driving record, what else are they supposed to do? Or how should they know? Other than reviews of people. So that would be interesting. How can Uber better equip themselves to avoiding having drivers that do this? It says Defendant Brogdon so negligent, wrongless, recklessly, and unlawfully operated the vehicle that Laura suffered injuries. Defendant New Forest Products failed to use due care in the hiring, supervision, selection, or retention of Brogdon. Defendant New Forest Products knew or should have known that Brogdon was unfit and incompetent to safely operate his vehicle. Again, how would they know? Like if I see somebody in a company vehicle, especially driving crazy, I do call it in. If they're just driving so reckless and they almost hit me or they almost hit somebody else, I will call them in. Now, whether they do anything about it or they're just like, somebody called about your driving today, like, and they don't do anything, and something happens and they knew of that report, that would be different. But I don't know how they're supposed to know these things. Causes of action. First cause of action, negligence against defendants Zayed, Brogdon, and Does 1 through 10. Plaintiff Laura Owens hereby re-alleges and incorporates by reference each and every allegation contained in the foregoing paragraphs as if fully set forth in details herein. Plaintiff Laura is informed and believed thereon alleged that the time of the subject collision, defendant Zayed negligently, carelessly, recklessly, and or unlawfully operated the gray 2009 Ford Escape with the California license plate so as to cause the subject collision. As a direct and legal result of the wrongful action and commission of defendant Zayed, Laura sustained considerable physical and mental injuries as a result of the traffic accident. Plaintiff Laura is informed and believed and thereon alleged that the time of the subject collision, defendant Brogdon negligently, carelessly, recklessly, and or unlawfully operated white 2000 GMC Sierra truck with a California license plate so as to cause the subject collision. As a direct and legal result of the wrongful actions and omissions of Defendant Brogdon, Laura sustained considerable physical and mental injuries as a result of the traffic accident. At the time the subject collision, Defendant Zaid and Brogdon were under a duty to comply with California Vehicular Code 22350. At the time of the subject collision, Zaid and Brogdon were under duty to comply with California Vehicle Code 21703, as well as 23123 and 23123.5. At the time of the subject collision, Defendants Zaid and Brogdon violated the above referenced statutes when they caused the collision, causing harm to Plaintiff Laura. Plaintiff Laura was among the class of persons for whose protection these statutes were afforded. As a direct and legal result of the wrongful conduct and or omissions and statutory violations of Defendant Zaid and Brogdon, Plaintiff Laura was injured in her health, strength, and activity and sustained injuries to her body and mind, all of which caused her great physical, mental, and emotional and nervous pain and suffering. Plaintiff Laura is informed and believes, and upon such information and belief, alleges that such injuries have resulted in debilitating injuries, all to her general damages in the amount according to proof at trial. As a further direct and legal result of wrongful conduct and or omissions of Defendants Zaid and Brogdon, Plaintiff Laura was required to employ physicians and other healthcare providers to examine, treat, and care for her injuries, and have had to incur medical and incidental expenses for such examinations, treatments, rehabilitation, and care in the amount according to proof at trial. So that's the first cause of action. Second cause of action, negligence entrustment against defendants of New Forest and Does 1 through 10. Plaintiff Laura hereby realleges and incorporates by reference of each and every allegation contained in the foregoing paragraphs if they were set forth in detail herein. On April 6, 2017, Defendant New Forest Products and Does 1 through 10 entrusted and permitted Defendant Brogdon to drive a truck for which they were the owner, bailer, leaser, and or licensee for the GMC 2000 truck. At the time, the defendant New Forest Products and Does 1 through 10 permitted or entrusted Defendant Brogdon to drive their truck and knew or should have known the Defendant Brogdon was incompetent or unfit to safely drive the vehicle. At all times preceding the collision, Defendant Brogdon incompetent and unfitness to drive was the legal cause of Plaintiff Laura's injuries. As a direct and legal result of aforementioned acts, Defendant New Forest Products and Does 1 through 2 and or each of them, Plaintiff Laura suffered the damages herein above set forth. Third cause of action, negligent hiring, training, and supervision against defendants Uber, Riser, and Does 11 through 20. Plaintiff Laura hereby realleges and incorporates by the reference each and every allegation contained in the foregoing paragraphs as if they were fully and set forth in detail herein. At all times herein above mentioned, Plaintiff Laura had the expectation that she would be safe and secure traveling in the MacArthur Tunnel in San Francisco. At all times herein mentioned, defendants Uber and Riser, and Does 11 through 20 had a responsibility to properly identify, screen, select, train, supervise, monitor, oversee, and or evaluate its employees and or independent contractors to ensure the fitness of each individual for employment in positions of transporting passengers in vehicles. At all times herein mentioned, defendant Zayed was unfit to transport passengers in his gray 2009 Ford Escape because he did not have liability insurance to act as a rideshare driver, the job he was hired for as required by California state law and or the terms of the defendant Zayed hire independent contractor relationship with Uber. Now, they should have some kind of notification or something in their system that says, hey, this person doesn't have insurance, and you can shut down their account to where they can't accept or take people on rides until they submit new insurance. That's one thing that they can do to ensure that people that don't have insurance aren't driving other people around. There's ways to fix that proper thing, but let's say he was fully insured and like all the boxes were checked except for the fact that he looked at his phone. Like, how is Uber to know? But with Uber should know that all their drivers have insurance, and if it says a person doesn't have insurance or their insurance lapsed, there should be some kind of notification where you can shut their account down and it doesn't work until they send in proper paperwork. Technology will allow that. All right. At all times herein mentioned, defendants Uber, Riser, and Does 11 through 20, and or each of them knew or should have known the defendant Zayed was unfit to operate the Ford Escape as a driver, and that his unfitness created a particular risk of harm to all passengers who stepped into his vehicle, such as Plaintiff Laura. As a result of the unfitness and of defendants described herein, Plaintiff Laura was seriously injured due to the accident that the defendant Zayed and Brogdon directly caused. As a direct and legal result of defendants Uber, Riser, and Does 11 through 20, and or each of their failure to properly identify, screen, select, train, supervise, monitor, oversee, and or evaluate the fitness of defendant Zayed as an operator of the Ford Escape, plaintiff suffers the injuries and damages herein above set forth. Prayer for relief. Wherefore, plaintiff pray that this court enter judgment in their favor on every claim for relief set forth above and award them relief including, but not limited to, the following. For general damages in an account according to proof at trial and beyond jurisdictional minimum of this court, for economic losses in the amount according to proof at trial, for the interest upon any judgment entered as provided by law, for medical and related expenses according to proof at trial, for the cost of the suit incurred herein, for such other and further relief as the court may deem just and proper. And it is signed by the attorney of Cotchett, Petrie, and McCarthy. It says jury demand. Plaintiff Laura demands trial by jury on all issues so triable. And it is signed on the 4th day of 2019 of April. All right. Then we have this, which was filed May 9th of 2019. And this is on behalf of Uber Technologies, Riser LLC, and Riser CA, which is California LLC, in the Superior Court of California, County of San Francisco, unlimited jurisdiction, in the case of Owens versus everybody. So this is the answer to the complaint. So this is their things according, they're answering to what we just read. So it says, comes now, defendant Riser LLC, hereinafter defendant, severing itself from all other co-defendants and answering the complaint hereinafter complaint on the complainant. And such negligence on the plaintiff's part constitutes a bar to any recovery by said plaintiff, or in the alternate, the recovery, if any, by said plaintiff should be reduced in proportion to the extent such negligence was caused of plaintiff's injuries and damages, if any. Third affirmative defense. As and for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges, plaintiff knowingly, willingly, and voluntarily assumed the risk of all damages, if any. So they're saying here, on the assumption of risk, it is on her. She took the risk to get into the car. Which, yes, but when we're taking those risks, we are under the assumption, per y'all's rules of your company, that everybody has had a background check, has insurance, and has a good driving record or obeys the laws. So, yeah, do it at your own risk, but we are to assume that all of your contracted drivers or workers are doing everything they should be per company's rules. We're not taking a risk just to hop in the car with anybody willy-nilly. Moving on to the fourth affirmative defense, the equitable indemnity. As and for separate and affirmative defense to the complainant and each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges, any and all events happening, injuries, and damages set forth in the complainant, if any, were proximately caused and contributed to by the acts and or omissions of plaintiff, and such acts and or omissions totally bar or reduce any recovery on the part of the plaintiff. Were caused and contributed by the acts of... I don't know if I'm buying that from Uber. I'm probably not going to be on Uber's side much in this lawsuit. We'll see, because there's a lot of issues that I have personally with Uber or Lyft or anything, but Uber for sure takes no responsibility. I mean, it is an act of Congress to get any information from Ubers, because they CYA on everything so that nothing comes back on them. And CYA just means cover your ass. They do that, and it's just slimy and schemy. I mean, even for authorities to find out about minors getting rides, it's an act of Congress, and it's like, well, you weren't supposed to be doing that without, a parent's acknowledgement or anything like that. Or at one point you weren't supposed to be picking up minors at all. Now they have parent ran accounts, but which still can be ran without parents, but that's a story for another day. But Uber likes to wash their hands clean of everything, and they're not handing over any information. Your information does stay very protected as far as them not giving it to anybody without search warrants. So let's go to the fifth affirmative defense, no duty. As and for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges, any recovery on the complainant or claim for relief averred therein is barred to all extent this answering defendant owed no duty to the plaintiff. I believe you have a duty to make sure you know who's working for you. I understand some circumstances it is hard, But there are things that you should be doing to make sure that people are safe. Because you're just sitting back earning all this money up in your corporate office while these drivers are doing all the work, and it could be endangering people's lives. But hey, you're getting paid, right? So I don't believe that the company having this driver owed no duty to Owens. I think they owe a duty to every passenger that gets into a car that is associated with them and contracts with them. Sixth affirmative defense. No causation. As in for separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes and based thereon alleges, to the extent plaintiff suffered damages which defendant denies, such injury or damage was not proximately caused by any conduct or inaction of this answering defendant or was not foreseeable or both. That's the thing. I mean, getting in an accident isn't always foreseeable. If your driver is doing something, yeah, that is foreseeable because you know that you're behaving dangerously on a road and you get into an accident. Now, this is her story. And so, was the driver actually on the phone when they had an accident? Like, if so, why are you suing the other driver who, like, if your driver was paying attention, this shouldn't have happened, but you're going to sue the other driver too? So, there's some things in here, but I guess when you have a suit like this, you just sue anybody and everybody and hope somebody can pay. But they're saying that, Uber says the denies injury or damage was not caused by the conduct of Uber. Well, through your contracted worker, it was. Maybe you yourself didn't, but your employee or 1099 contractor did. Seventh affirmative defense. Alleged injury or damage caused by others. As in for separate and affirmative defense to the complainant and to each purported cause of action complained therein, this answering defendant is informed and believes and based thereon alleges, to the extent plaintiff suffered injury or damage which defendant denies, so they're saying we don't think she suffered any of this. Such injury or damage was caused by the action or conduct of others, not this defendant. So they're blaming everything on the driver, not them. Which, yes, it is the driver's fault or the people on the road, but they are connected to you, and you have a responsibility to your passengers. Sorry, you do. Eighth affirmative defense. As and for separate and affirmative defense to the complaint, and so each purported cause of action contained therein, the answering defendant is informed and believes and based thereon alleges, to the extent plaintiff suffered injury or damage, which defendant denies such injury or damage was sustained prior to the incident alleged by the plaintiff in the complaint on file herein. So this is existing prior injury. So they're saying if she suffered something on a prior injury, it wasn't made, it had nothing to do with them. Ninth affirmative defense, uncertainty. As and for the separate and affirmative defense to the complainant and to each of the purported cause of action contained therein, this answering defendant is informed and believes and based thereon alleges plaintiff's complaint and the allegations thereof are uncertain, vague, and ambiguous. So they're saying there is not enough detail. You're just like, we got into an accident with these two vehicles. The end. It's your fault. Driver was texting. And supposedly he has no insurance. So they're saying, oh, this is vague and ambiguous. I don't know that it is, because it's talking about a single report. Maybe they need to become more detailed in their next, complaint or affidavits or whatever. But I don't know that it's vague and ambiguous. 10th affirmation defense, limitation on damages. As and for separate and affirmative defense to the complainant and to each purported cause of action contained therein, the answering defendant is informed and believes, and based thereon alleges, plaintiff's complaint seeks an award of improper damages, including but not limited to medical damage beyond those permitted by law. So they're saying there's a limitation on these damages, and it goes towards like medical, seeks an award of improper damage. So they're not limited to the medical damages, but the other stuff, there's limitations on it. And asking for an infinite number over 25,000, they're saying that needs to be limited. 11th affirmative defense, offset. As in for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believed and based thereon alleges the cost incurred or paid by the plaintiff, if any, for repair of property damage, medical care, dental care, custodial care, or rehabilitation services, loss of earning, or other economic loss in the past or future were or will with reasonable certainty be replaced or indemnified in whole or in part from one or more collateral sources, including by or through insurance available to the plaintiff under the terms of the Patient Protection and Affordable Care Act. And as such, the defendant is entitled to have any award reduced in the amount of such payments. So they're saying there is an act out here for this stuff. That stuff needs to be reducted off of our costs, is what I'm thinking they're saying. I am not a lawyer or an insurance person. That's just how I'm reading it. If you read it another way, let me know. 12th affirmative defense, Howe v. Hamilton meets. As and for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges, plaintiff's recovery for past medical expenses or other economic loss or benefit, if any, is limited to the lesser of the amount paid or the reasonable value of those services or benefits. 13 affirmative defense, Patient Protection and Affordable Care Act. So here's where we're going to learn about that. As and for separate and affirmative defense, complaint to each purported cause of action therein, believes and based on their alleges, plaintiff is excluded from recovering any amounts which have been or will indemnify plaintiff for any past or future claimed medical expenses, health care, life care, or other economics, loss, benefit that is offered or provided under or in the connection with the Patient Protection and Affordable Care Act. Okay, that really didn't tell us anything except for what they basically said already. 14th amended affirmative defense, failure to obtain health insurance. As and for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes based on thereon alleges, in the event plaintiff has failed to obtain health insurance coverage available to plaintiff, which they're eligible for under the Patient Protection and Affordable Care Act, plaintiff has failed to mitigate plaintiff's damages and cannot recover for such failure. So they're saying, if you don't have insurance, and because you chose not to have insurance, and so you don't have anything, like insurance isn't paying for part of it, so you have to pay for it all out of pocket, it is not on us that you chose to not have coverage. And we should not have to pay the entire amount. Like what they should be responsible for if it was a person with insurance is maybe the cost after insurance has covered their part, and they can pick up the rest of it. But they don't want to pay for it because she's chosen not to have insurance, which I don't know if they know she has health insurance or doesn't have health insurance. She sure makes a lot of fake doctor's appointments, or maybe even real ones that turn into something else. But so I don't know if she has health insurance or not when this happened. Who knows with her. 15th affirmative defense, failure to utilize health insurance benefits. And they start as and for the separate affirmative. This answering defendant is informed and believes, based thereon alleges, to the extent plaintiff failed to take reasonable steps to utilize the resources, service benefits, and coverage available to plaintiff under the Patient Protection and Affordable Care Act, plaintiff has failed to mitigate plaintiff's damages and cannot recover for such failure. You don't get to just get all this extra money because you chose not to have insurance that would cover part of this. Because that's what insurance is for, is to cover things. So you don't get extra money just because you didn't do that. And it's going to cost you more out of pocket now. Okay, let's go to 16th. Affirmative defense, Affordable Care Act, and further damages. So it says this answering defendant is informed and believes, and based thereon alleges, plaintiff will not be limited to the reasonable value, if any, or future medical services available to the plaintiff under the Affordable Care Act. 17th affirmative defense, no injury or damage. So as for the which is in every single one of them, it says this answering defendant is informed and believes, based on their alleges, this answering defendant denies plaintiff suffered any injury or damage whatsoever, and further denies it is liable to plaintiff for any injury, damage claimed, or for any injury or damage whatsoever. So I don't know why they say that there is no damage. We shall see how this thing unfolds, but they're saying there's no injury or damage. So many affirmative defenses. So we're on the 18th, which is vicarious liability. So they're saying the answering defendant denies plaintiff suffered any injury or damages whatsoever, and further denies its vicarious liability for the acts of other parties. 19th affirmative defense, fails to state facts general. So it says the complainant and each purported cause of action contained therein fails to state facts sufficient to constitute a cause of action against his answering defendant. That is true. She's like, we got into a wreck. You're responsible. You need to pay. But she didn't state anything in there that was like, this is why you need to pay. This is what needs to happen. I had to, it gave me seizures and I now have to deal with this for the rest of my life. And, I had to go to this doctor and this hospital. Like, it doesn't state any of that. It just says, I had to go to the doctor. This accident messed me up. Y'all are at fault. The end. Like it so I get where they're like, oh, vague and ambiguous in that way, because it really doesn't state why. Like, if you were somebody that was caught in a fire or something from a place who didn't have, their fire code wasn't up to date, and you're like, okay, we went to this concert, this happened, because of it, we couldn't exit, we couldn't see, and then, I got burnt, I almost died, it took, 50% of my skin off, I had to have 7 surgeries, I was in the hospital for this many days due to the negligence and all that, but you need to have more specifics about what happened to you. Not, I feel like you owe me money because I was in an accident. Sometimes accidents happen and there's nothing to give money for. Maybe car damage, but that's not your car. So you don't get the money for car damage. So she didn't even get money for the damaged car. The driver would have to sue for that, and he wouldn't dare if he's cause of the wreck. So, yeah, there needs to be more facts about that. I do get that. Okay, 20th affirmative, statute of limitations, which this is interesting because it does sound like this happened in 2017, but she didn't file until 2019, which there's probably a 2-year statute, which is why she filed it. But why did it take her that long to decide to sue? So it says each said cause of action is barred by the applicable statute of limitations, including but not limited to the California Code of Civil Procedure sections 335(1), 337, 337(1), 337(15), 338, 339, 340, and 343. And then we've got 21st affirmative defense, failure to mitigate loss. And so if plaintiff suffered any damage as a result of allegations set forth in the complaint, plaintiff is not entitled to recover from answering defendant any sum of the damages due to plaintiff's failure to take reasonable efforts to mitigate the damages said plaintiff allegedly occurred. How could she have mitigated some of these? So, anyways, 22nd affirmative defense says, answering defendant is informed and believed and based thereon alleges each and every cause of action or purported cause of action contained in the complainant is barred by the doctrine of estoppel. Okay, let's see here. Waiver. Each and every cause of action or purported cause of action contained in the complainant is barred by the doctrine of waiver, which I would like to see what that waiver says. Do you say that you can't sue them if something happens if you get into their car? Because that would be very, very interesting. Then we've got 24th affirmative, latches. Each and every cause of action, purported cause of action contained in the complaint is barred by the doctrine of latches. 25th, unclean hands. And each and every cause in the action, purported cause of action contained in the complaint is barred by the doctrine of unclean hands. And then we've got collateral estoppel. So let's see what the 26th affirmative defense is. And so we have in the 26th, it says each and every cause of action or purported cause of action contained in the complainant is barred by the doctrine of collateral estoppel. And so basically they're saying that they are trying to keep Owens from taking advantage of their wrong by asserting legal rights that are unconscionable, but I don't know what Owens would have done wrong here by getting into a car. I get that it's meant to like set boundaries and things like that, and you can't just go after everything, such as if you didn't get insurance to cover part of your stuff, that's not their fault. And then, the doctrine of waiver was about you voluntarily gave up your rights and legal rights under certain things, which sometimes we do. That's why it's important to read the fine print, even though none of us want to read all that hoopla, but it can be important. And then the laches thing they were talking about, it says the doctrine of laches is a legal principle that allows courts to deny a claimant relief if they delayed asserting their claim in an unreasonable manner. Estoppel by laches. And so things that I found, it said that she was well within her time period that she could file this if it happened in 2017 and she's filing in 2019. It's still within the time limit. They're just trying to make that argument because if it sticks, great for them. But if it doesn't, it doesn't. They go on, but they made the argument. And then the things about, oh, you said, you signed something that says you can't sue us. Well, a lot of businesses have arbitration clauses in them. And so it's kind of saying you can't sue them, like take it to court. They're wanting you to do an out of a court to try to resolve the matter. Don't put it to a jury or a judge. They don't want to take it to court. But most people do take it to court because the companies don't want to interact in arbitration. They don't want to do mediation. They don't want to try to settle with you beforehand. They're like, take me to court, basically, is kind of where they put you at. So you don't really have a choice. And I'm sorry, I don't think there is any 100 proof non-liability waiver or anything out there. That would be really interesting that you sign something and they are saying no matter what happens, if you die, because you signed on this dotted line, you cannot sue us. And because you're taking this risk. But there has got to be loopholes in those where if something just abhorrent happened and it was just straight negligence and something on the company's part, I feel like you have the right to sue, whether you signed on that dotted line or not. Now, you can sign a waiver that says, we aren't going to sue. And, if everything's working properly and the employee is doing their job and they are being employee of the week and everything at their job, but for some reason you get in there not knowing you have a heart issue and I'm thinking maybe if you go into one of those like fly zone things where the air like makes you fly and you're in that little tunnel tube thing, that if you have some unknown heart condition and you for some reason in there end up dying, that has nothing to do with the company causing that death. You are the one, knowingly or unknowingly, that went into the little fly zone and did that, and it just so happened that you died as a reason. That's not the company's fault. That was just something weird with your health. It sucks and it's tragic, but the company didn't do anything wrong. Like there are scenarios like that and you can't sue them just because they died on your property. Like they died at your business. It's not the company's fault. Just like it's not McDonald's fault if you're fat. You went through the drive-thru. So I can get it to an extent. But I don't think that there's just anything where any company can ever say nobody ever, never can sue us. moving on back into this. So, they're saying that the plaintiff engaged in conduct with respect to the activities and or property which are the subject of the complaint, and by reason of said activities and conduct is stopped from asserting any claims or damages or seeking any other relief against the answering defendant. 28th affirmative defense, damages uncertain. As for and separate affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believed and based thereon alleges plaintiff's damages, if any, are speculative, uncertain, and not capable of being determined by a trier of fact. I don't know how damages can be speculated if she's dealing with them, or uncertain. That's interesting. Because, yeah, of course, uncertain things and imaginary things can't be determined by a fact finder. 29th affirmative defense, intervening, superseding causes. Answering defendant is informed and believed and based thereon alleges the damages of which plaintiff complains were proximately caused or contributed to by acts, other defendants, persons, and or other entities. Such acts were an intervening, supervening, and superseding cause of the injuries and damages, if any, of which the plaintiff complains, thus barring plaintiff from any recovery against the answering defendant. So they're saying this is everybody else's fault. We have nothing to do with this. And maybe that's true if it was just a normal wreck. Like it just randomly happened. But that may not be what happened here. The 30th affirmative defense. No vicarious or agency liability. So the defendant alleges that at no time or place set forth the complainant did any other defendant or third person alleged to be at fault operate as the agent or employee of the defendant such that defendant can be held vicarious liability for their acts. Should any other defendant or third party be deemed to have any affiliation with this defendant, then such other defendant or third party was independently responsible for their own means and methods. Accordingly, the doctrines of respondent, superior, and agency are inapplicable, and this answering defendant has no vicarious liability for acts or omissions by said other defendants and third parties. So they're saying we are not responsible for what any of our third-party contractor people do, which I don't see how that's possible. 31st, affirmative defense, independent contractor. The answering defendant alleges that the complainant and each cause of action set forth therein are barred, in whole or in part, under the independent contractor defense, as the independent third-party transportation provider was an independent contractor responsible the independent third-party transportation provider's own means and methods, making the doctrine of respondent superior inapplicable. So that may be true, but you should cut them off from being, you can terminate their contract if they are not doing everything that a contracted worker is supposed to do. Says 32nd affirmative defense is failure to state cause of action. The answering defendant is informed and believes, and thereon alleges the complainant in each and every cause of action therein alleged against defendant fails to set forth sufficient to constitute a cause of action against this answering defendant. 33rd affirmative defense, joint and several liability. Answering alleges that the liability of this answering defendant for the Ison economic damages claimed or proven by plaintiff shall be and is limited by the California Civil Code 1431.2. All right, and these are going to be our last 2 pages for this video. So let's get through these. 34th affirmative defense, lack of capacity to sue. Defendant is informed and believes and based thereon alleges plaintiff lack legal capacity to sue and is not the real party in interest and is thus barred from recovering against the answering defendant. 35th affirmative defense, sudden emergency doctrine. As and for separate affirmative defense to the complainant to each purported cause of action contained therein, this answering defendant is informed and believes and based thereon alleges any and all claims that the plaintiff may have or have had against defendant have been or will be barred by the sudden emergency doctrine. Okay, and then we've got the 36th affirmative defense, which is consent. And it says, well, before we go there, a sudden emergency doctrine is a legal principle that can excuse a person from liability if they act reasonable and prudently in an emergency situation. It's also known as a common law emergency doctrine. It applies when someone is faced with an unexpected situation that leaves little time for thought, and that they must prove they were not at fault for the situation, which obviously if you're not behind the wheel, how are you at fault? That it was unexpected. Unexpected. You're sitting in the back of the car and all of a sudden you get into this accident. That a reasonable person would have concluded the situation was serious. And the defendant's actions were reasonable and prudent. So some examples of sudden emergencies would be like child begins choking in a car, a falling object from a tree overpass or the back of a truck lands on your car. So these are things that are beyond the party's control. Something that is through no fault of their own, which if you are riding as a passenger, it is not your fault unless you were acting cray-cray in the back of the Uber and like just messing with them or trying to take over their car, stuff like that. So I don't know if this sudden emergency doctrine that they're trying to say, she doesn't meet the things to do that, so it should be barred just based on that defense. I don't think that defense is going to work. So going back to the consent, says answering defendant is informed and believes based on thereon alleges each and every cause of action or purported cause of action contained in the complaint is barred due to the consent by plaintiff to all actions alleged therein. Yeah, she signed a consent, but under what pretenses? Under false pretenses? Or was the driver doing everything they possibly could to pay attention to the road and be a good driver? 37th affirmative defense, the independent third-party transportation provider is contractually obligated to defend, indemnify, and hold defendant harmless for all claims asserted by plaintiff. 38th affirmative defense, arbitration agreement. This dispute is subject to an arbitration agreement between plaintiff and the answering defendant, such that this matter properly brought before a qualified arbitrator rather than a court, which we kind of went over that. There is a clause in there that says you agree to arbitration, not courts. So it needs to go through an arbitrator, not a judge. And you're going to the judge when you're not supposed to be. So this needs to be thrown out, is basically what they're saying. Now the 39th is no seatbelt usage. I think they're just covering their butts, but because, and they need to, because, you know, that she didn't state in her complaint whether she had health insurance. She didn't state in her complaint what injuries she had, or what fully caused them, how the car wrecked. Did it flip over? Did it do, like she said, you know, it turned the other way, but there's a lot more to it. Was she wearing a seatbelt? She didn't put that in there. So they need to cover, if you weren't wearing a seatbelt, that's on you. If you didn't have health care insurance, that's on you. So while we may be responsible for some of this, we're not taking the blame for everything. They want you to be the perfect plaintiff if you're going to sue. You have to have no screw-ups to come after us, is how the companies want to be. Which, buckle your seatbelts, people. Whether you think it's cool or not, I don't care. Buckle your seatbelts. So it says defendant is informed and believes thereon alleges plaintiff's recovery is barred or proportionately reduced due to plaintiff's failure to wear the available restraining device or to wear it properly. So maybe she put it on, but she put the little strap that goes in front of you behind her. Maybe because if she was in the back seat, she just didn't put it on. Maybe she didn't wear it at all. We don't know. They're saying that she didn't wear a seatbelt. I don't know how they know that or don't know that. Because I feel like whether she was wearing a seatbelt or not, she would claim she was wearing her seatbelt. Maybe the driver told them that she wasn't wearing one. I don't know. Maybe they can get that off of the car details, if that's even able to do. I don't know how they would find that out, because I don't see her admitting that. 40th, good Lord, 40 affirmative defenses in this thing. Reserved defenses. As and for separate affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant alleges that it presently has insufficient knowledge or insufficient information upon which to form a belief as to whether it may have additionally yet unasserted affirmative defenses. Defendant therefore reserves the right to assert additional affirmative defenses in the event discovery indicates it would be appropriate. So they're saying we laid out 40 of these things, but we may have 41 and more in the future depending on what else comes out. And so they reserve the right to have those. And then it says, wherefore this answering defendant prays for judgment as follows. Number 1, the plaintiff takes nothing by virtue of plaintiff's complaint. 2, for cost and suit incurred herein. I don't think you're getting that one. 3, for such other and further relief as the court may deem just and proper. And then it's signed by the attorneys for the defendants, Uber Technologies, Razor, and Razor on May 9th, 2019. I don't think they're going to be getting any financial relief, but that is to come later. So this is the beginning of Owens versus Uber and the drivers and everybody else that can be connected to this in any form or fashion. We have more coming up in future videos, so please like this video, subscribe, and turn those notification bells on if you want to make sure you're notified for when part 2 of this case review of the Uber lawsuit comes out. And I will see you next time. Bye.